Hi, I'm Max Savoy. I'm a partner at the international law firm Ashurst. I'm joined by two of my colleagues, Hannah Pack and Tannen Quek, who are both senior associates at Ashurst. The three of us focus on advising firms across the payments sector, particularly on regulatory requirements. We do quite a lot of work on cross-border payments, which is the topic of this webinar. In this webinar, we're going to be focusing, as the name suggests, on cross-border payments, so on the provision of payment services from one jurisdiction into another, payments from one country to another. We're not going to do a deep dive into the regulatory rules that apply to payment service providers in the UK. What we're going to be doing is looking thematically at the sorts of legal and regulatory issues that come up when firms are providing cross-border payments or cross-border payment services. We're going to cover a few things. We're going to start by talking about, or I'm going to start by talking about when legal regulatory issues arise in the context of cross-border payment services. We're going to talk about regulatory licensing, often called authorization or registration requirements, when those may be triggered by cross-border activities or cross-border payments. Financial crime, which is a big issue area for the payment sector, rules including requirements restricting, preventing anti-money laundering, financial sanctions, funds transfer or travel rule requirements, which is about information accompanying payment transactions, and then data privacy and security. Payments are, by their nature, often quite data-rich services. They involve transfers of personal data, they involve data relating to credit cards, bank accounts, things that fraudsters would often love to get their hands on. And if some of that data falls into the wrong hands, there can be significant harm caused to customers and to the market at large. So it's unsurprising that there are lots of rules governing that.